in order for us to grant your variance request, you may present your information. Feel free to, you don't have to stick to what you have written here. You can add information. We do have drawings here, so whenever you need to reference to any of the other information you submitted, just let me know and I'll do my best to share what we have with the board here. So with that, I'll turn it over to you.
All right. Thank you, Mr. Chair. And thank you, board, for hearing our case. As it was introduced, the property that we are presenting is lot 1868. This is a family lot that has been passed down to me and my wife. And a little background, we've been working with the town of Litchfield since roughly March, April of 2020, trying to figure out what steps we need to complete in order to settle out this land in terms of the heirs, as well as build a single family home on it. Over the summer, we completed a lot line adjustment with the other heir. That's lot 1862. We took two unequal lots and we split it. And as you'll notice on the map, there's kind of a little bit of a dog leg to the Morrill Street right away. We created that in order to maintain access to that other lot. Previously, lot 1868 had access from both right of ways. It was the only lot in the area that had access. So we split that access with John Nelson, who owns lot 1862 and 1864, the next two southerly lots to us, ensuring that he had access to his, and that was unanimously passed by the planning board. Once we completed that with the planning board and it was recorded with the registry of deeds, we had to work with the town. We were directed by town administrator Brown, along with members of the planning board and the board of selectmen and the town's attorney, on the use of the right-of-way for our lot. We were instructed that we needed to make sure we could use that lot as an access point for a single-family home, and we could restore it to essentially a driveway standard before we could present our case for the frontage to you folks. That's why our application was originally submitted in September, and we had to postpone and wait for some for that to all go through. So as I believe Mr. Brown had forwarded to you the minutes and agreement from the Board of Selectmen, we presented a plan to restore it was the Garden Drive right away. As it's drawn on a tax map, it would appear there is a street there, but there is not. It was all woods. And we presented a standard that well surpassed driveway standard, but was somewhere in the middle ground of a public road standard based on financial reasons, and just that it was unnecessary to bring it to the full class 5 for a single home. The Board of Selectmen unanimously approved that restoration. And we do have a signed agreement and release with the town of Litchfield pending disapproval, that we will maintain the right of way and we will host all liabilities. So the town does not take any costs associated with maintaining it. No liabilities with this. We will restore it, maintain access to our property, and shoulder those liabilities. If you're looking at the map, getting to the ordinance, it touches, we have 50 feet of road frontage where it touches the theoretical paper street, as it's been referred to by the town. There's a number of these in town. As you can see, there's another one just on this tax map, the Morrill Street, that is also a paper street. There's a number of these in the north of the town. There was some off of Page Road before the Weatherstone development was there. There were some off of Rotterdam, Cortland Ave. They're throughout the town, and they were created by the planning board for future access to those lots that are abutting subdivisions. The subdivision that created the right of way for us was approved in 1999, and it left us with this this one access here. Well, now one access. It was two, but they were both the same exact undeveloped paper street. No improvements had been made by the town or developers of either the Pearson Street development or the Grove and Homestead developments. If you look closer at the site plan, you'll notice that where it does touch the road approved and built in 1999 Court and Homestead Court, there are two pins that denote 100-foot road frontage to that road. So if you're looking at it as you were driving down that road, you would see a house on either side, and then there is a 100-foot flare from that 50-foot right of way that cuts through. Again, those were designed and approved back then for future roadways and subdivisions, if that is what the land was used for. Our family has never wished to pursue a subdivision, and we wish to keep this land mostly wooded. So in terms of the frontage, again, it's 50 feet to that paper street, and it's 100 feet where it touches Grove and Homestead Court. And with RSA 674-41, that let us pursue a building permit based off of the right of way being shown on a previously approved subdivision plan or plat. And again, the Board of Selectmen, the town's attorney, they have all supported our pursuant of that RSA. In terms of the 5 criteria, the variance will not be contrary to public interest because allowing access to our property does not contradict the intent of the statute. It does not alter the character of the neighborhood or threaten the health, safety, and general welfare of the public. And it's also, this lot is substantially greater than all other requirements. And this is, with the agreement release, it will force us to live one home on this property. That agreement release will be tied to our deed. So we can never build more than one single family dwelling on the property. The spirit of the ordinance is observed because there is no other access point to the property and the lot exceeds all the other minimum requirements. It is utilizing an approved future access point approved by the abutting subdivision plan, again, from the planning board's approval in 1999. Substantial justice is done because otherwise the land would be landlocked by surrounding subdivisions, properties, and deemed inaccessible and not usable for any other purposes at this time. The value of surrounding properties are not diminished because the property will be used for a single family dwelling built with like square footage and value to the surrounding abutters. The values of the surrounding properties would not be diminished as the structure will remain in line with the parcel characteristics and neighborhood characteristics. And lastly, the literal enforcement of the provisions of this ordinance would result in a necessary hardship because the property only has one access point, which has been created by the surrounding subdivisions and properties, in its dimensions were created with less than minimum lot frontage. We emailed a couple of abutter supporting letters today. It's the two abutting properties of either side of that right of way. Richard Gamache of One Homestead Court and Heidi Miller of Two Grove Court. She's actually the originally inherited the land, and it's being passed off to us. We're working on that process right now. Was the board able to receive those, or would you like me to read the letters?
I did not get those. I apologize. I'm not sure if they were, I don't recall if I looked at my zoning board account before I left the house.
That's okay. I'll read them aloud. We apologize. We had sent these when we met with the Board of Selectmen, and we thought we had sent them to you as well, Richard. So I'll read. It's we basically they've both been great about this, and it says, "Dear board members, I, Richard Gamache, a butter located at 1 Homestead Court, Litchfield, New Hampshire 03052. Support the intentions of Seth and Hannah Miller to build a single-family home on their property, lot 1868. I understand and support the request for the restoration of the Garden Drive right-of-way to be built as presented to the Board of Selectmen by the Millers for the purpose of access to their property and the proposed dwelling. I understand and support their request for a variance for the minimum road frontage has to be presented to the Zoning Board of Adjustment pending the Board of Selectmen's acceptance of the restoration of the Garden Drive extension right away. This notice was made this 30th day of November 2020, and it was signed. And it's the same letter from Heidi Miller of 2 Grove Court. Again, we had to. The Board of Selectmen asked that we just get a butter support specifically to that right away restoration, which we received and again, the board approved. The only other, since we had presented this, we had learned of the open space development that was used by the planning board for Firefly Way. And we didn't know if that would apply to us being the 90 feet of frontage, given that we are also leaving a significant area wooded. We have performed a forestry management on this property, and we have cleared a portion of the property based on our forester's recommendation of the time of year to do it that would cause the least amount of impact to the land. So we have cleared an area for what would be used for a house, but over 25 acres remains wooded and keeps that green space going. That continues down through the trolley track area. There's a brook that's undisturbed, and that maintains, a green area all the way to the Sawbrook Fields. So we were unsure. No one had brought up that at the time, and honestly, we're new to this, but we're trying to do everything we can to work with the town and pursue this in the correct fashion. So in studying the planning board regulations, we did see that open space development frontage that was 90 feet rather than the 150. Does anyone have any questions that I can answer at this time?
Yeah, I have one. So the road, I'm looking at I'm looking at the drawings that we have available, the town tax map, as well as the drawings you submitted. And if I understand this correctly, where that paper road touches your property, it's 50 feet. You
Correct.
draw back a little bit, that's the 100-foot that you referred to right at that intersection that goes down to the cul-de-sac.
Correct.
So, and now I think what I mean, so one thing I guess what I'm trying to get to is exactly how many feet are we talking about here in terms of the variance? Is it something from the 150-foot requirement or something from a 90-foot requirement that I think you just described?
I'm not sure. I'm honestly not sure. We had talked with the planning board. We had asked if we needed to present to the planning board, and we were told no, because we're not presenting a new subdivision. So, like Firefly Way, that was a developer came seeking a subdivision, and they requested, instead of the traditional residential planning standards, that it met the open space development standard. So I apologize if I confused anyone. I was more just asking a question, or just curious if our situation would justify the open space development frontage standard. But by the letter of our map in our legal piece, it is 50 feet where it touches that paper street. The 100 feet just comes into play that the Board of Selectmen have agreed to let us use that as our access and restore it as a private access and driveway to our lot. And where that touches the road, the previously restored Class 5 road, Grove Court and Homestead Court is 100 feet. So
technically speaking, though, you'd be seeking, you would only end up with 50 feet of frontage. So we'd be looking for a 100-foot variance from the 150-foot requirement.
I believe that's correct. Yes.
Okay. Just wanted to make absolutely sure on that I was clear.
Or if the other applies, it'd be a 40-foot variance from the 90.
If the other applied, but obviously if we were to vote on the larger of the two, he's covered either way.
Right.
Which is really what the application, I think, is before us.
Okay.
Is from the 50-foot from 100-foot from the 150-foot requirement, leaving basically a 50-foot frontage. I do want to, first of all, I want to say on the abutter notices, if you have sent those to my Litchfield, New Hampshire.gov email, great. If you haven't, please do. I'll make sure that gets into the record for the file.
Yes, we did send those. We apologize. It was probably 2 or 3 hours ago. We've had a bit of a family emergency the past week, and we had just realized that we hadn't sent those.
No, that's quite all right. I hope everything's okay. I want to read a couple of things into the record here. I've got Exhibit 3 here, which is from Troy Brown, our town administrator. This is an email dated Wednesday, January 13th, 2:53 p.m. In the email, he's stating Chairman Riley and Vice Chairperson Gandia, this email and attached file is not intended to influence your decision on the Garden Drive ZBA case this evening. I want the ZBA to know that the Board of Selectmen have been working with the Millers to grant legal access to their lot. On November 23rd, 2020, the Selectmen agreed to grant permission to the Millers to make improvements to the Garden Drive extension right-of-way for private access to their property. The right-of-way was officially named by the Board of Selectmen on January 11th, 2021 as Hale Way. This was all reviewed and approved by the fire department as well. The planning board has no legal authority in this matter. If you have any questions or concerns that come up tonight, feel free to contact. And then Mr. Brown provided his contact information. Attached to that, which I've labeled as Exhibit 4, this was an attachment to that email I just read you. This is essentially an agreement and release that Mr. Miller was referring to in his presentation. I got 3 pages here, so I don't think I need to read through the entire thing. It essentially is, as Mr. Miller stated, it is a copy of minutes from the selectmen meeting where this matter was discussed, and it was a 4-0-0 vote to grant permission as being described here in this evening. So I can pass it on if anybody wants to read it, but in the interest of time, I mean, Laura, I'll ask, do I need to read the entire thing into the record? You're muted.
It's only that little bit. I probably would. Just that bit from Selectmen minutes.
John's going to read it because I'm getting tired.
Where do I start?
Where the green is highlighted.
Okay, see. Whereas landowner is the owner of the real property located in Litchfield, New Hampshire, described in deed record book and this blank at the Hillsborough County Register of Deeds whereas the town has agreed to issue a building permit for the construction of one single-family resident of property upon the execution and recording of this agreement pursuant to New Hampshire Revised Statutes annotated 674:41, 1B2, Bravo 2, that is. Now therefore, the town and the landowner, on behalf of him or herself, his or her heirs, legal representative, successor, and assigns, covenant and agree as follows. The town shall issue a building permit to the landowner to construct a single-family resident on the property, provided that all conditions, requirements set forth in the town ordinances and regulations are met. Number two, the town assumes neither responsibility for maintenance, including snow plowing, nor liability for any damages resulting from the use of the road. Item three, landowner shall be responsible for maintaining access to the property and does hereby forever release and discharge the town, its officers, agents, and employees from any obligation for maintaining the road and from any claim of any nature, whether in tort or otherwise, which landowner has or may in the future have against the town for any loss or damage, including those incurred through failure to provide municipal services, including without limitation, police, fire, and ambulance services arising out of the condition of the road from the point where the road begins. Landowners shall hold harmless and indemnify the town from any and all claims, suits, costs, and other expenses, including reasonable attorney's fees, whether brought by the landowner or third parties, arising out of the use and occupation of the property and the maintenance of the repair of the road. Item four, landowner assumes responsibility for the maintenance and repair of the road to be used solely as access to a single-family residence. In addition, the landowner agrees to clear and solely maintain the road to a width of not less than 16 feet and to repair and maintain the traveled portion of the road in a good and passable condition at all times. The town shall have no responsibility for obtaining contribution from other users of the road for such costs of maintenance and repair. Item five, the road may be renamed provided the town and landowner agree the road and property will be easily identifiable by emergency vehicles, residents, mail carriers, etc., from the point at which the road begins. Item six, the obligation of the town of the landowner to the town of the landowner, if more than one, shall be joint and several. Item seven, an original or certified copy of the agreement shall be recorded in the Hillsbury County Registry of Deeds. This agreement shall be deemed run with the property and shall be binding on all successors to the landowner's interest in the property, unless the road is improved upon by the landowner to a Class 5 standard as described in the town ordinances and regulations and accepted by the town as classified by the New Hampshire Revised Statutes annotated 229:5. Wherefore, the parties have executed this agreement and released as of, and then they have the selectmen signatures.
Signature page.
Signature page.
Very good. Thank you, John.
My pleasure.
All right, so that's all the other evidence that we had in the file, drawing, which we've already discussed as well. So, let me go back to the board. Does the board have additional questions for Mr. Miller?
I have a question.
Please.
I know there's been talk about the fire department's approval. I don't know what the fire department actually approved or looked at. When I've done stuff like this before, there's been concern with fire department having the ability to, drive on that driveway. So there's been conditions that have been placed in other cases that I've worked on regarding the material, the width of the driveway, and stuff like that. So for us to elaborate on what your interaction with the fire department is, that'd be great.
So we had presented a standard, basically the section from Grove Court, Homestead Court to our lot. It exceeded all the Litchfield regulations for a residential driveway. Again, the minimum width is 12 feet, and they had 12 inches of aggregate. We have over 12 inches of aggregate, plus we have a paved portion, a substantial apron, and the width is 16 feet plus shoulders on it. It also has large turnarounds for vehicles to be used. And so everything met or exceeded the driveway standard. It just didn't go up to a class 5 road standard, being in width, as described in the planning standards. The fire department, their main concern was naming of the road, again, so it's easily identifiable. We had presented Hale, after my grandmother, Candace Hale, lifelong resident of Litchfield. And we had just asked for Hale Court, given that it was Grove Court, Homestead Court, Hale Court. The fire department had advised us, per E911 and of the regulations, that they're trying to standardize the use of ways and lanes for restored right-of-ways of this nature. If you consider Adams Way, Warren Adams, his private drive, things like that, the Strawberry Lane. So although in the past these have been granted for other names, they just asked that we use Hale Way or Lane. And at this past Monday's meeting, the board had approved Hale Way for that use. But the fire department did not present any concerns with the construction standard. And if you refer back to the minutes, Kevin Lynch had commented on the standards that were approved over the years. He was the building inspector, and he had advised that this was well surpassed minimum standards, and this will not limit access to anyone. Myself, I am a firefighter, and I believe me, the last thing I would ever want to do is design something that would limit access for protection for my own home. So that's the construction standard part of it that was approved. And if you folks would like documents for that, I can forward that to you as well, or it's in the minutes from the selectmen meeting that's in reference.
Thank you.
Any other questions for the applicant before I open it up to public?
I actually had one thing I forgot to mention. In doing our research on this project and this presentation, we did find one property in town that was built in 2016 that we believe very much mimic the access that we have. It's 1 Maple Court off of Aldridge. It's about a 6-acre lot that has 50 feet frontage, according to what I could see on the tax maps, to scale. And that is now labeled as 1 Maple Court. And then that was one house, one single family home that was built under kind of the Eversource power line right away in the southern part of town, just off of Talent Road, Laurel and Aldridge Court. So
I wonder if that was the one we did for Lynch. Sounds that way. They had made some changes to 2 lots that were side by side in order to be able to make the most of it out of that second lot. The one that was already encumbered. Thank you for that additional information. I appreciate it.
you're welcome. Thank you.
Any other questions from zoning board members before I open it up to the public? All right, at this point in time, what I would like to do is open the meeting up to members of the public who would wish to speak, either in favor or in opposition to Mr. Miller's request